Here at Scott Legal, we know the ins and outs of immigration. We are here to help you navigate the oftentimes complex road in achieving your immigration goals. We have new immigration videos every week. If you are new to the channel, please hit the subscribe button and bell. You can also sign up for one of our webinars, or get a free immigration guide, by clicking the link below. In this video, we'll be discussing U.S. citizenship for military service members. Let's get started. Members and veterans who have served in the U.S. military and are not U.S. citizens may be able to qualify for citizenship based on their time served in the military, or their period of service. Non-citizen U.S. military service members must meet some, but not all the naturalization requirements to obtain citizenship.
What are some regular naturalization requirements for all applicants?
The applicant must demonstrate at time of examination an ability to understand English, including the ability to read, write and speak English. The applicant must demonstrate at time of examination knowledge of U.S. history and government. The applicant must demonstrate good moral character for at least 5 years prior to the filing of the application, and up to the time of naturalization. And the applicant must adhere to the principles of the U.S. Constitution, and be well disposed to the good order and happiness of the United States during all relevant periods under the law.
What is citizenship based on 1 year of military service?
This is a special provision for U.S. military service members to become eligible for citizenship based on military service during peacetime, pursuant to Section 328 of the Immigration and Nationality Act.
What are eligibility requirements other than the regular naturalization requirements?
Military service-related requirements include the following. 1. The applicant must be 18 years of age or older at time of application. 2. The applicant must have served honorably at any time in the U.S. Armed Forces for a period, or periods totaling at least 1 year. And 3. The applicant must be a legal permanent resident at the time of examination of the application.
What naturalization requirements are waived?
Applicants who file while presently serving or within 6 months of honorable discharge are exempt from the continuous residence and physical presence requirements for naturalization. Continuous residence is the minimum amount of time a legal permanent resident must maintain legal permanent resident status to normally qualify for citizenship. Physical presence is the minimum amount of time a legal permanent resident must physically be present in the United States to qualify for citizenship. Applicants who file 6 months or more after discharge must demonstrate continuous residence for at least 5 years, or 3 years if legal permanent resident status was obtained through marriage to a U.S. citizen spouse. Applicants must also prove physical presence in the United States for at least 30 months of the 5 years, or 18 months of the 3 years, if the legal permanent resident obtained status through marriage to a U.S. citizen spouse. However, the applicant can count the time in honorable service within the 5-year period immediately preceding the date of filing the application, as time towards residence and physical presence within the United States.
What about U.S. citizenship eligibility based on military service during hostilities?
This is a special provision for U.S. military service members to become eligible for citizenship based on military service during designated periods of hostilities, pursuant to Section 329 of the Immigration and Nationality Act. Eligibility requirements other than the regular naturalization requirements include military service-related requirements. The applicant may be of any age. The non-citizen service member must have served honorably at any time in the U.S. Armed Forces during a designated period of hostility. The applicant must either be a legal permanent resident, or have been physically present at the time of enlistment, re-enlistment or extension of service or induction in the U.S. Armed Forces. This includes presence in the United States, Canal Zone, American Samoa or Swains Island, or on board a public vessel owned or operated by the United States in non-commercial service. If the applicant has served during multiple periods, the applicant must demonstrate at least one qualifying period of service to establish eligibility.
What naturalization requirements are waived?
Applicants who file on the basis of military service during hostilities are exempt from the general naturalization requirements of continuous residence and physical presence. However, it should be noted that even though the period of continuous residence and physical residence will be waived, the non-citizen serviceman must still demonstrate 5 years of good moral character.
What are the designated periods of hostilities?
The designated periods of hostilities include the following. World War I with dates, April 6, 1917, to November 11, 1918. World War II with dates, September 1, 1939, to December 31, 1946. Korean conflict with dates, June 25, 1950, to July 1, 1955. Vietnam hostilities with dates, February 28, 1961, to October 15, 1978. Persian Gulf conflict with dates, August 2, 1990, to April 11, 1991. And War on Terrorism with dates, September 11, 2001 to the present.
What are the filing requirements for citizenship, based on military service?
Whether qualifying based on service during hostilities or 1 year of service, a filing fee is not required. Furthermore, it is important to understand for either basis of eligibility that honorable service includes service in active or reserve service in any branch of the U.S. military, including the Coast Guard, Space Force and the National Guard. Discharge from service must have occurred under honorable conditions. Discharge based on other than honorable, bad conduct, and dishonorable do not qualify as honorable conditions. Required forms for the application include the application for naturalization Form N-400, as well as Form N-426, which is typically completed by an armed service certifying official within 6 months of submitting the N-400. Applicants discharged from military service for 6 months or more are not required to have the Form N-426 certified. However, the form must still be submitted, and applicants must submit photocopies of their Certificate of Release or Discharge from Active Duty Form 214, or other official discharge documents demonstrating periods of service to demonstrate honorable service. To learn more, take a look at our resources in the description box below. You can also sign up for a free visa guide, any of our upcoming webinars, and Facebook groups. You can also schedule a consultation for a date and time that is best for you. We are here to help. You can contact us by calling 212-223-2964 or by sending us an email. We look forward to hearing from you.